Okay, so before we begin, it should be noted that both of us are essential workers, and if we have corona, we have corona. Okay? We're both very at risk right now, and my sister is also at risk because she's an essential worker, and my mom is being reckless. So, you know what? We're already in danger as it is.
You'll have to pardon the lack of 6 plastic flexible rulers between us during this challenging time.
Welcome back.
Welcome back to the Bastard Show. I bet you thought you'd seen The Last of Us. However,
I apologize for this taking 6 months, but there... Aside from the worldly things going on, we've both have had a very hard time.
bro, I went to college. Immediate L right there. And then I met a man, and that was an even bigger L.
So yes, we're doing this 6 months late because we're sad and incompetent, and dark academia waits for no one. We decided, because it was Pride Month and there's anti-police protests going on, that we would, finish this.
It seems timely.
Because we spent 6 months being sick and going to college. So, in the first episode of Gays Against Cops, we established that, Europe and the United States have been very anti-queer people since the beginning of time.
For real.
When a certain culture takes over the entire world,
it makes everybody anti-queer.
so, it makes your judicial system and police a bit anti-queer as well.
Yeah.
And when we left off, we were establishing that sodomy laws are probably one of the... Yeah, bullshit, and one of the biggest reasons why police are bastards when it comes to queer people.
Yeah, that was one of the biggest legal justifications, because cops, at least sometimes, like to pretend there is a legal reason that they are being bastards. I think last time we covered everything, but just in case this is your first time, watching the long-standing series Gays Against Cops. As a general note, we're talking about gays against cops and cops against gays. So we're talking about a lot of historical stuff that involves some upsetting content, homophobia, transphobia, police brutality. There's going to be talking about death and mutilation and some other upsetting topics.
Major trigger warning.
Yeah. We're going to try to keep things as PG-13 as possible. Obviously, some of the laws that have been established in this historical course have to do with sex. Maybe don't watch this in front of your grandma, but we're going to be talking about it in legal, historical, and sociological contexts. We're not just sitting here talking about sex or whatever.
Ignoring sex in gay history is
you can't really do that.
It's deeply intertwined because of the sodomy laws.
Sex was one of the biggest justifications that was used to create legal oppression and, laws and shit like that. Ooh, laws. Hate those. So where'd we leave off? Thank you for asking. We're starting with the 1900s. This is less time than we covered in the entire previous video, but more shit happened. Because, there's technology and there's all sorts of civil rights movements.
And it's more documented. We have more information.
So starting off actually a little before the 1900s, late 1800s, like the 1890s, up through the 1920s, that was the Progressive Era. And that was kind of one of the first times in American history when people were like, hey, shit sucks, and we should do something about it on a really big scale that involves laws and other structures like that. You see a lot of widespread activism and social reform happening in the Progressive Era. People rallied for government action to address stuff like child labor and corporate greed, anti-immigration laws and stuff like that. And this is when we start to see queer rights becoming a centralized activist movement. That first started in 1924 with Henry Gerber founding the Society for Human Rights. That was the first official queer rights group. Gerber published Friendship and Freedom through the Society for Human Rights. That was the first gay periodical. In 1925, Gerber and several of his colleagues were arrested in relation to the publishing of this periodical. No charges were issued, but Gerber's belongings were confiscated, and he went through a whole long-ass court proceeding and other legal bullshit related. I forgot we have to censor all these swears. Queer people began connecting more in the 1900s, and that's due to a lot of reasons. Transportation became, a more accessible thing. Blues women in Harlem began performing in jazz clubs and writing music about their queer love. The term bull dyker, which later spawned the term dyke, emerged because of queer women of color in the Harlem Renaissance. The 1920s also saw the birth of ball culture in New York City, which would later spawn Vogue and house and related genres of music, dance, and community, that encouraged queer men to engage in dance, fashion, and other traditionally feminine pursuits. It's important to note, though, that the ball culture of the 20s is totally different than the ball culture of the 60s, which is what we all think of when we think of drag and Vogue. Ball culture in the 20s was still super fucking racist, and queens of color often were either denied ability to go into clubs or they had to paint their faces lighter if they wanted to participate, which is fucking icky. And that's a form of community policing. Right now we're laying down a lot of history and kind of moving through a timeline of what queer people have gone to in specific relation to their legal rights, their civil rights, and their relationship with the police. Right now, the police haven't been involved a ton. We're gonna get into some court cases later where police become more involved. A lot of the things we've seen so far are forms of community policing, where the general public functions under the colonial homophobic and transphobic standards that were set back in the 15 and 1600s. And that sort of forces queer people collectively into the closet and makes it very taboo and unacceptable to practice a lot of behaviors that would be considered queer, like men pursuing dance and fashion and stuff like that became popular in the 20s.
We'll start seeing actual or better documented, we'll say, police involvement around the 1920s when we start talking about the gay bars.
Also, the term coming out originated roughly between the 20s and 30s, and to come out was at the time to make one's debut in the gay and lesbian nightlife scene, but that and it was a widely celebrated community event, and that was obviously later adapted to mean, telling your friends, families, coworkers, loved ones, what have you, that you're queer. So gay culture was kind of taking shape at this point. We have a lot of subcultures evolving. We see things happening in the realms of music and fashion and art, stuff like that. But dominant American culture was still frowning down upon queerness, and so was the law. Sodomy laws that we saw going slack in the 1900s started to shape up and get a fresh coat of paint during the 1920s. For example, a 1923 supplementary sodomy law in New York City made it a crime to frequent or loiter in any public place soliciting men for the purpose of committing a crime against nature or other lewdness. And that kind of follows in the vein of moral turpitude laws, and that's like an old legal term that was basically just made it illegal to do anything that was icky. And icky was a standard that was totally arbitrary and up for, privileged majorities to decide what it meant. And it wasn't just queer marriages or gathering spots that were heavily regulated either. Sexual interaction, as we have seen throughout this entire discussion about sodomy laws, was really heavily monitored, starting roughly around this time period. This is gonna become important later.
And here we have a statistic that kind of shows how the police have already been sort of involved with detaining and arresting these queer folks just being queer. A study published in 1938 found that out of 100 gay men in New York prison having been convicted for sex crimes, 97% were convicted of sex acts with another adult. The testimony from the study claimed that some of the judges, for one reason or another, imposed jail sentences on all homosexuals, even in the case of first offenders. Anti-cop rhetoric is also anti-judge rhetoric a lot of the time, because they work together hand in hand to oppress people.
And this is something that hasn't really changed. This sort of legal precedent set a lot of societal beliefs that kind of villainized queer people as being very lewd, perverted, pedophilic individuals, you know, stereotypes about gay men preying on your little sons, and about lesbians trying to chase after straight girls, and about transgender women just being, you know, kinky freaks, stuff like that. A lot of those beliefs that still linger around today was set by the laws and the actions of police during the 20s, 30s, and 40s.
Casual American propaganda.
It's all related, baby.
And because of these sodomy laws, the prisons were filled with queer people, as you can imagine, and this resulted in prison officials abusing their power. There was a lot of sexual assault, blackmail, just violence, sexual violence.
It's also not something that has changed. Modern statistics will show you that transgender people are imprisoned at roughly 3 times the rate of the general public, and they're disproportionately punished, they're housed with the wrong gender, they're subjected to violence, and denied access to healthcare. If you Google the case of Michelle Leal Noseworthy, she was arrested under Kamala Harris's, you know, fucking reign of terror, as I believe she was district attorney of San Francisco at the time. Kamala Harris was in charge in like 2014, I believe, when a transgender woman was gang raped in one of her prisons and immediately denied healthcare afterwards, and it became a big fucking deal. But the point is that this hasn't changed.
Basically the same.
Transgender people especially, and queer people in general, are still overrepresented in prison populations, and they experience disproportionately high rates of violence, both at the hands of prison officials and, you know, inmates, other inmates, as well as they're housed with the wrong gender, and they're often denied access to healthcare. And when we're talking about prisons, just remember, prisons wouldn't exist without police to fill them. These issues hold hands, and we need to address both of them simultaneously. Medicine!
This is...
Dear fucking Christ, medicine. Just in general, attempts to medicalize queerness, which is something we've talked about ad fucking nauseum. You can check out our other videos about medicalizing transgender experience, True Scum versus Too Cute, stuff like that. Those are a bit more modern interpretations of this whole issue, but don't get me wrong, it's existed for a long fucking time. And now we're looking at some of the roots of it.
People that defend medicalizing queer people do not know queer history.
Yeah.
So
It's literally just regurgitating violently homophobic and transphobic sentiment that's been watered down to seem like it's just a fringe Tumblr issue, but this was something that had people killed and sterilized in massive groups. So attempts to medicalize queer experiences grew super fucking popular in the 30s and 40s, and it was influenced in no short degree by anti-gay eugenics happening in Nazi Germany roughly around the same time. In 1937, New York City Mayor LaGuardia ordered all prisoners who were convicted of sexually perverse crimes, again, very vague legal term that can be interpreted however they needed it to be to ensure that queer people got arrested. All prisoners convicted of sexually perverse crimes were to be kept under indefinite medical observation. And in 1939, in People v. Hall, a county court decided that sodomy was unusual and unnatural, and a normal person would not commit the crime. Who would commit the crime? Asked this opinion. It certainly is essential to inquire into the mental attitude and physical reactions of a man charged with this crime. So that's the language taken directly from the opinion issued by this county court, basically saying, if you commit sodomy, if you are gay, then you must be mentally ill. And obviously, it's appropriate to keep mentally ill people in prison so that they can be medically monitored indefinitely. Lobotomized. In New York, like everywhere, but especially in New York, medicine was continually weaponized against queer people. A 1942 medical journal described a gay sexual psychopath being lobotomized by the state, and in 1943, a study was published detailing New York's attempts to treat young men who had been caught in same-sex relationships. The treatment included repeated imprisonments and correctional schools. Hey, what does the phrase correctional school remind you of?
Correctional. Conversion?
That's the shit. None of that was scripted, by the way. Conversion therapy, that was a thing too, unfucking fortunately. It was popularized in 1935, although its roots go all the way back into the 1890s. It was popularized by local fuckhead Sigmund Freud. Fuck that dude.
You know how I feel about him.
Sigmund Freud would not last a fucking day on Stan Twitter.
Sigmund Freud is over party.
Sigmund Freud claimed that he could abolish homosexuality and make normal heterosexuality take its place through conversion therapy. And by 1952, homosexuality was classified as a mental disorder by the APA. And as we go into the 60s, conversion therapy became less about talking patients out of being gay and more about violence. Aversion therapy, which is an element of conversion therapy, was used to create a negative association with queerness. It's the same principle as you spray your cat with a water bottle when they do something bad, only it's gay people and their lives. Gay men would be shown homoerotic photos and then given electric shocks on the hands or genitals to create an association between pain and gayness. Other aversion therapy techniques included using exposure to bad smells, foul tastes, and the use of nausea-inducing drugs. Another medicalizing technique that was wielded against incarcerated queer folks in particular was state-sanctioned forced sterilization. This is something that America has wielded against marginalized populations throughout history, and in a lot of different ways. People overseas have been sterilized by the American military. Indigenous people were sterilized in the 1500s when colonization first set up its camps here on Turtle Island. Sterilization has been used very heavily against black women in a lot of different ways. Seriously, Google the roots of Planned Parenthood. You'll be surprised and upset by what you find, but it's necessary. Read Medical Apartheid. Sterilization has been a tool that America has used against marginalized populations roughly forever and roughly everywhere, if I'm being scientifically accurate with the coverage. This is why I am personally vehemently anti-eugenics. Eugenics is getting popular again, and I fucking hate that. And it's becoming very subversive and kind of sanitized in ways where people don't realize what they're talking about or advocating for or reading about is eugenic in nature. Especially with discussions of how there's a new reproductive technology like gene sorting where you can, make sure that your hypothetical unborn child will not have Down syndrome or autism or other unpleasant, unfavorable, what have you, genetic disorders.
It's genetic genocide.
Yeah. That's eugenics, and it's genocide. In America, this began with the Portland Vice scandal stemming from a 1912 shoplifting arrest of a 19-year-old boy who claimed that he had been corrupted by older homosexual men. What a fucking excuse that was. After this arrest and the information related to the case became public, it was a fucking scandal, okay? Men were arrested on accusations of indecent conduct and sodomy. More than 50 men were implicated and 7 were convicted. One of the implicated men was driven to suicide by public humiliation. However, the most severe consequence of this scandal was a push for northwestern states to adopt compulsory sterilization laws for sex offenders. Compulsory sterilization legally originated in 1907 in Indiana. That was the world's first sterilization law. It was used as a punishment for various male same-sex interactions, which was reported to have made up to 1/3 of the inmates at the Jeffersonville Reformatory in Indiana. Basically what we said, it's large groups of gay men being arrested for daring to be in a gay relationship and then being forcibly sterilized, and that was legal.
At this point, I took over the document, and it kind of... I tried to remain on a timeline, but my brain goes, okay, big picture, buddy.
For real. I'd be like details, and Nick be like a big picture.
So this one's called Police Cross-Dressing in Gay Bars. We got into some of the nitty-gritty at the beginning, but this is like the big thing with police and queer people, is that the police were very good at arresting people for being gay.
Yeah, surveillance tactics were used a lot. Undercover officers following people into their homes, doing stakes and stings, shit like that. Arrests out the fucking wazoo.
The first thing we have to acknowledge, gay bars were places where a lot of queer people would interact with one another. It led to a lot of crackdowns on these gay bars, and it led to alcohol licenses not being given to supposed immoral characters. Like, there was a literal law against giving an alcohol license to an immoral character, which that is very fucking subjective.
Yeah. And that forced queer people out of, like, one of the only, industries, if you will, where they were able to make a living and shit like that. It's one of the reasons that, like, the cycle of poverty is overrepresented in queer people and queer families.
So police would just fucking raid gay bars all the time and arrest people, and nobody would stop them. They would just do it. And it should be noted that the people in power would collaborate with the police in extortion and blackmail schemes.
Yeah, judges, lawyers, bail bondsmen. Bail bondsmen.
Quote, many judges, lawyers, bail bondsmen, and police participated in blackmail and extortion schemes that targeted LGBTQ people. Undercover police also entrapped LGBTQ people, persuading them to engage in illegal sexual acts that they might otherwise have not committed. Not only sodomy laws and alcohol licensing laws allowed for police to, arrest people for being gay, but also, like, these cross-dressing laws allowed for the police to routinely arrest genderqueer people, trans people, drag queens, and, other queer folks. The funny thing about these laws, right, is that they used old laws that did not pertain to cross-dressing in the first place. Like, they did not pertain to queer people, these old laws. Now, these laws were called the Masquerade Laws, and let me read this quote from history.com. Laws criminalizing cross-dressing spread like wildfire around the United States in the mid-19th century. New York's, dating back to 1845, was one of the oldest. It declared it a crime to have your face painted, discolored, covered, or concealed, or be otherwise disguised while in a road or a public highway. The state originally intended the law to punish rural farmers who had taken to dressing like Native Americans to fight off tax collectors. But as scholar William N. Eskridge Jr. recounts in his encyclopedic book, Gay Law, by the beginning of the 20th century, gender inappropriateness was increasingly considered a sickness and a public offense. So, once again, this was not even about gender or cross-dressing. These masquerade laws were about dressing like Native Americans. They were manipulating these old laws to fit their narrative so that they could arrest people for not dressing the way that they wanted them to. In Brooklyn in 1913, for instance, a person who we would today call a transgender man was arrested for masquerading in men's clothes, smoking and drinking in a bar. When the magistrate noted that the state's masquerade law was intended only to criminalize costume dress used as a cover for another crime, the police were forced to let the man go. However, they promptly rearrested him and charged him with associating with idle and vicious persons, and found a new magistrate to try the case. When he was found guilty and sentenced to 3 years in a reformatory, the judge made it clear that despite the new change, he was being punished for his dress. No girl would dress in men's clothing unless she is twisted in her moral viewpoint, the magistrate proclaimed from the bench, according to a September 3rd, 1913 article in the Brooklyn Daily Eagle. As you can see, if one judge didn't like their case, they would just move to a new one and retry the case. They did everything in their power to arrest queer people for being queer.
Yeah.
And they would do it over and over and over again until they got you. They didn't like losing.
And regarding especially the policing of expression and what people were able to perceive as queer, and what I meant when I said that hasn't really changed, I'm looking at one of the few studies of its kind done in 2018, a small-scale study that analyzes the interactions between homeless queer youth and police, so very specific, very vulnerable populations being targeted by police. One transgender woman was interviewed regarding her experiences trying to get into a homeless shelter, and she was turned away and specifically told, quote, "I'm a boy and I should dress like one." So that very same language about you're X, so you should dress like Y, otherwise you will be arrested, you will be criminalized, you will be denied access or denied use of a service. Like, that has not changed. It's just been interpreted different ways. And a homeless shelter saying that to a homeless queer person is an example of community policing because they're not using a law to uphold it. But as we have obviously seen, the actual police used it as well.
I felt like this was important to put here, despite the fact that it was used pretty much from like the 1940s all the way through like fucking the 1970s, 1980s, but the 3-article rule. The 3-article rule is a bastard rule that appeared out of the masquerade laws to police queer people. Fun fact, there is nothing in the laws that specifically state that the police could arrest people for this.
Yeah, you won't look through any state's legal code and find something called a 3-article rule. It was a kind of an implied standard of policing at the time.
The 3-article rule is essentially you needed to wear at least 3 pieces of clothing that matched their assigned sex gender, or they could be arrested. This rule was often used as a reason to bust queer spaces like gay bars.
Kate Redburn, who's a JD PhD candidate in queer and trans legal history at Yale University, did some research trying to find out more about 3-article laws since there wasn't any like legal documentation of their existence. And some of the clues they found were that requirements for a certain number of gendered pieces of clothing often came up in memoirs from queer people during the 30s, 40s, all the way up through the 60s, really. And secondly, a lot of cross-dressing laws at the time did mention a certain number of gendered pieces of clothing. That wasn't like the meat and potatoes of the law, it was a little side piece. Redburn turned to different kinds of sources, legal codes as well, including military law and police manuals, and didn't really find anything, so they came up with 2 explanations. Either the 3-article rule was, an informal law of thumb, sort of an implied standard for police, or it was a term used by the LGBT community themselves to describe what was happening and kind of warn each other,
The police also used this to sexually harass trans men and queer women. And I quote, Mitchell also noticed an additional wrinkle. Gay men and transgender women who mentioned the 3-article rule were usually being arrested in bar raids. Lesbians and trans men, on the other hand, were being accosted in bars and on the streets. Police were using this to check their underwear. Mitchell says, using the law as an excuse for street-level sexual assault and sexual humiliation. Oh boy.
The military.
The military banned queer people. I mean, you could have guessed it, but the military.
The military.
If you were caught being queer in the military in like the 1940s through like the 1960s or whatever, whenever there was a certain point where they had to like ignore it because war.
Yeah, they needed as many people as possible. It's like the same way that the Puritans were like death penalty for being queer, but so many people were already dying of starvation that they were like, oh fuck, maybe we can't kill more people.
Yeah, exactly.
Exactly. They're like, you can stay, but you're on thin fucking ice.
But yeah, if you were caught, you would get a dishonorable discharge, which means you went to prison.
You go to jail, and then when you get out, nobody ever gives you a job again.
So basically the police went, haha, get fucked.
For real.
Yeah, you're serving your country? And
Die.
you're gay?
Your Honor, gay. Death penalty.
The big one. The big boy. What we are celebrating this month. Stonewall Riots. The police raids based on sodomy laws, public indecency laws, the 3-article rule, and laws prohibiting alcohol being served to queer people were still a commonplace in 1969. They did not stop. There have been protests of these raids previously, like the sit-ins of 1966 by the Medicalization Society, where they openly declared their sexuality at taverns, daring staff to turn them away, and suing establishments who did. When the Commission on Human Rights ruled that gay individuals had the right to be served in bars, police raids were temporarily reduced.
A lot of the gay bars at the time were run by the mafia, since their very existence was a crime, and the mafia's like, ooh, crime.
The mafia's like, I can make money off of sodomy. Gay people?
Gay people? Gay bar raids were just a fact of life at this time, but usually mafia owners would be tipped off before raids because, mafia paid the police department to not get arrested and,
And the mafia were straight for the most part, and the police did not care. They just wanted to arrest gay people.
They just wanted that sweet, sweet mafia money. This did not happen at the Stonewall Inn on June 28th, 1969, however. Armed with a warrant, police officers entered the club, roughed up patrons, and they found bootlegged alcohol. They arrested 13 people, including employees, and people violating the state's gender-appropriative clothing statute.
Which isn't a
The
thing.
three-piece article, what fucking ever. Female officers would take people they suspected of being cross-dressing into the bathroom to check their sex.
That's so gross.
This raid angered patrons and the surrounding neighborhood. They hung around the bar rather than dispersing when the police showed up, and they got increasingly angry as cops became more violent and as the night unfolded. At one point, an officer hit a lesbian over the head as he forced her into the police van. She shouted at the onlookers to act and incited the crowd to begin throwing pennies, bottles, cobblestones, and other objects at the police. This started what is now known as the Stonewall Riots. So this was not just a singular riot, it was about 5 days of continuous rioting all across New York. On the 1-year anniversary of the riots, on June 28th, 1970, thousands of people marched in the streets of Manhattan from the Stonewall Inn to Central Park in what was then called Christopher Street Liberation Day. That was America's first gay pride parade, and that's what we celebrate today in June when we all go to the nearest big city and watch fucking nonprofits march in the street or something. This is what pride is. It's a celebration of the Stonewall Riots.
It's an anti-cop riot we are celebrating.
For real, this started because a lesbian experienced police brutality and shouted at onlookers to act. This is why we say things like no cops at Pride.
There's a reason why no cop should be at Pride. It is so fucking disrespectful to the history of Pride.
Mm-hmm. The gist you need to get is that Stonewall challenged a lot of issues. Challenging the police and military was obviously the biggest one, but fighting poverty and upending the traditional nuclear family. First and foremost, Stonewall was a rebellion against the police and the criminal legal system. Protesters resisted and attacked the police. They were fed up with police harassment, entrapment, and violence. Stonewall was an uprising against discriminatory incarceration of LGBT people and other people targeted by the police.
The police have never been queer people's friends.
Not fucking ever. And not now, either.
The 1970s and the 1980s.
Those were years, weren't they?
The Stonewall Riots were like a catalyst for a bunch of major law reforms. Laws against sodomy, buggery, crimes against nature, disorderly conduct, immorality, indecency, lewdness, loitering, solicitation, and vagrancy were repealed or revised in many states and cities. There were also pushes to ban employment discrimination, and some places began to allow you to change your sex marker on legal documents. Several states and cities passed hate crime laws to protect queer people from violent acts of discrimination. Homosexuality was no longer classified as a mental illness, which also meant people were no longer deported for it.
A lot of steps in the right direction, so it would seem.
But also gay people were blamed for the AIDS epidemic.
Yeah, then the AIDS epidemic happened.
This was a thing that was planted by Christian and rightist activists. Mm-hmm. They were the ones that sort of spread the whole, haha, gay people AIDS.
Despite all of those reforms, a lot of states still have not kind of joined in these pro-queer rights laws. The anti-sodomy law reforms slowed down in the 1980s, and progress started to go backwards. For like a hot minute, everything was good, and it seemed to be moving in the right direction, and we were repealing laws and reforming legislature and kind of reshaping how people thought of queerness and of queer people, kind of fixing some of the more social issues. And then it all went down the fucking drain. So the pace of sodomy law reform slowed down in the 80s, and by the end of the decade, sodomy remained criminalized in about half of the United States and various US territories as well. and the U.S. military, and in U.S. prisons. Some states, including Montana and Texas in 1973, Kentucky in 74, Arkansas, Missouri, and Nevada in 77, and Tennessee in 89, joined Kansas in creating new distinctions between same-sex sodomy, which was criminalized, and cross-sex sodomy, which was not criminalized. In 1975, Virginia increased its penalty for sodomy from 3 to 5 years in prison. In 1974, Cincinnati passed a new law against cross-dressing. Most of the states that did repeal their sodomy laws in the 60s, 70s, and 80s passed new laws against loitering to solicit sodomy. So it's the same fucking thing. Police in some locations, including Denver, Colorado, used these and some other laws to increase their arrests of queer people after sodomy law repeal. People of color, sex workers, and people who pursued sex in public places, not to say that they fucked in public, but like they tried to arrange hookups in public. So you know how nightclubs work, you've seen them before. Those were distinctly vulnerable populations to discriminatory policing. Bowers versus Hardwick in 1986. So this is from the case description itself. Michael Hardwick was observed by a Georgia police officer while engaging in the act of consensual homosexual sodomy with another adult in the bedroom of his home. After being charged with violating a Georgia statute that criminalized sodomy, Hardwick challenged the statute's constitutionality in federal district court. Following a ruling that Hardwick failed to state a claim, the court dismissed. On appeal, the Court of Appeals reversed and remanded, holding that Georgia's statute was unconstitutional. Georgia's Attorney General, Michael J. Bowers, appealed to the Supreme Court and was granted certiorari. So the court was divided and found there was no constitutional protection for the acts of sodomy and that states could outlaw sodomy practices. Justice Brian White argued that the court has acted to protect rights not easily identifiable in the Constitution only when those rights are implicit in the concept of ordered liberty, or when they are deeply rooted in the nation's history and tradition. And both of those quotes are citing other Supreme Court cases. The court held that the right to commit sodomy did not meet either of those standards. White feared that guaranteeing a right to sodomy would be the product of judge-made constitutional law and would send the court down the road of illegitimacy.
They said being gay would make the Supreme Court illegitimate. That's what happened in the Bowers versus Hardwick case, essentially.
Yeah, for real. Basically, they fell back on the idea. There's 9 different schools of interpretation for the Constitution, depending on how strict you want to be with the wording, and its application to problems that did not exist at the writing of the Constitution. And they basically kind of use that as a scapegoat to say, well, there's nothing in the Constitution that says you can have gay butt sex.
There's nothing preventing states from banning you from having gay butt sex.
For real! And so that was followed by Romer versus Evans. Colorado voters adopted Amendment 2 to their state constitution, precluding any judicial, legislative, or executive action designed to protect persons from discrimination based on their, quote, homosexual, lesbian, or bisexual orientation, conduct, practices, or relationships. Following a legal change by homosexual and other aggrieved parties, tag yourself, I'm an aggrieved homosexual party, the state trial court entered a permanent injunction enjoining Amendment 2's enforcement. The Colorado Supreme Court affirmed on the appeal.
It should be noted that this happened in 1996, so not that... that's 5 years before I was born.
In a 6-3 decision, the Colorado Supreme Court held that Amendment 2 of the Colorado State Constitution violated the Equal Protection Clause. Amendment 2 singled out homosexual and bisexual persons, imposing on them a broad disability by denying them the right to seek and receive specific legal protection from discrimination. In his opinion for the court, Justice Anthony Kennedy noted that oftentimes a law will be sustained under the Equal Protection Clause so long as it can be shown to, quote, advance a legitimate government interest. Amendment 2, by depriving persons of equal protection under the law due to their sexual orientation, failed to advance such a legitimate interest.
This was a win, and one of the first wins in a Supreme Court case.
Yeah, following several losses, specifically in Colorado. It's important to note that even when states have, their little legal fights at the appeal level or at the state constitution level, that does set legal precedent that the Supreme Court can use. So don't overlook state-specific cases when you're, thinking about laws and shit. I worded that maybe the worst way I could have possibly strung any words together in a sentence to convey a meaning. So entering the 2000s, Lawrence versus Texas, which is kind of like the brother case of Bowers versus Hardwick.
This is the biggest win for gay people. This is where they were kind of like, hey, maybe we can't put you in jail for sodomy.
Yeah, every now and again, the court looks at something they did like 20 or 30 or 40 years prior and they go, maybe we shouldn't have done that. That happens every once in a blue moon.
Oopsie.
Because we made a fucky wucky and put your civil rights in the forever box. Now we're taking them out again. So everything's okay. Stop trying to reform us.
Houston police entered John Lawrence's apartment and saw him and another adult man, Tyron Garner, engaging in a private consensual sexual act. Lawrence and Garner were arrested and convicted of deviant sexual intercourse in violation of a Texas statute forbidding two persons of the same sex to engage in certain intimate sexual conduct. In affirming, the state court of appeals held that the statute was not unconstitutional under the Due Process Clause of the 14th Amendment with Bowers versus Hardwick. They used Bowers versus Hardwick as a precedent in this case. However, in a 6-3 opinion delivered by Justice Anthony M. Kennedy, the court held that the Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conduct violates the Due Process Clause. After explaining what it deemed the doubtful and overstated premises of Bowers, the court reasoned that the case turned on whether Lawrence and Garner were free as adults to engage in private conduct in the exercise of their liberty under the Due Process Clause. That sentence almost killed me.
Reading Supreme Court case opinions are fucking awful.
I think I took 50 cosmic damage. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government, wrote Justice Kennedy. The Texas statute furthers no legitimate state of interest which can justify its intrusion into the personal and private life of the individual, continued Justice Kennedy. Accordingly, the court overruled Bowers.
Yeah, this is one of the first court cases that interpreted that the Constitution said citizens have a right to privacy. Basically a right to do what you want in your own home as long as it doesn't violate obscenity laws. And that's a different set of laws, basically saying you can't fuck animals or children.
So the Supreme Court said gays can fuck.
Gays can fuck.
It should be noted that despite the sodomy laws essentially being overruled by the Supreme Court, they also weren't really overruled. They were, but they weren't.
A certain method of enforcing sodomy laws became not necessarily illegal, but if it happened, a gay person now had the legal precedent to win a court case against it.
It was a little extra protection. And it should also be noted that police harassment did not end there. Of course not. Why would it end there?
Yeah. In 2012, the National Coalition of Anti-Violence Programs released an audio press conference which had its annual report documenting the high levels of hate violence experienced by queer people and HIV-affected persons in the United States. Some of the highlights of that, essentially, were that of survivors reporting to the police, 48% reported incidents of police misconduct, which was a considerable increase from 2011, the year prior, which saw a 32% occurrence.
That's a crazy jump.
For fucking real. And of the violence survivors who interacted with police, 26.8% reported that the police attitudes were hostile, which is an 18% increase from 2011.
Another jump, so it's not getting better, it's getting worse. This is from this current decade.
Transgender people are 3.32 times more likely to experience police violence compared to non-transgender people. Transgender people of color were 2.6 times as likely to experience physical violence by the police as compared to white cisgender people. Transgender women are 2.9 times more likely to experience violence overall at the hands of the police compared to overall people reporting violence. And lastly, transgender women were 2.71 times more likely to experience physical violence by the police compared to overall people reporting violence.
So the police are still bastards. Nothing changed,
and this
especially.
Essentially answers the question, why don't survivors go to the police? And that's a question that is posed at domestic violence survivors, rape survivors, assault survivors. Basically anybody who has been the victim of a violent crime and lived to tell the tale. They often get asked, why didn't you go to the police? It's because A, the police don't fucking listen to you, and B, if they do, you usually end up worse off for it.
And in 2015, so literally only 5 years ago, the US Transgender Survey found that 58% of respondents who interacted with police who knew they were transgender experienced mistreatment, including verbal harassment, persistent misgendering, physical and sexual assault, and being forced to perform sexual acts to avoid arrest. Nearly half of the transgender survey respondents said they feel uncomfortable seeking police assistance.
I just want to supplement that with a more specific anecdotal testimony from that 2018 report I was citing earlier, which was talking about how police interact with homeless queer youth. Some of the anecdotal evidence from that were just essentially supporting that idea that police don't fucking know how to interact with queer people, or they do it violently. One quote from a gay male interviewee said, "I was real shook up. I held my boyfriend's hand. The cop came up to us, looked at us holding hands. He said, 'You a couple?' I said, 'Yeah.' He looked like he wanted to puke. He said, 'Wait here,' and then went to talk to another cop. The other cop came over and talked to us instead. The other cop seemed cool that I was holding a guy's hand." Helen, the transgender woman whose story with the homeless shelter I talked about earlier, also reported an incident in which an officer seemed to mock her for being transgender. Quote, "I was pulled over, asked for license and registration, but the license didn't match my appearance. One cop said, 'So what's going on here?' He was talking about the way I dressed. I explained. Him and the other cop went to their car. I could hear them laughing. One came back and said, 'Be more careful.'" So even if it's not explicit violence, cops don't know how to treat queer people, essentially.
And when the cops are laughing at you and your gender marker, you certainly feel endangered.
Yeah, how do you ask for help to somebody who's laughing at you or giving you a dirty look? How do you ask for help from somebody who's coming at you violently?
How do you know they're not going to take out a gun and shoot you, and then you will have no justice for it because the justice system doesn't prosecute cops, and because of the trans gay panic laws?
Oh yeah, remember when we talked about that a few videos back? Yeah, that's still a fucking thing in like 46 states.
Like I said before, even though sodomy laws were technically outlawed, they're technically useless now because they can be protected by the Supreme Court. There are many states that still use these sodomy laws, even though they're technically not valid. 13 state statutes support to ban all forms of sodomy, some including oral intercourse, regardless of the participants' genders, but it's mostly used against gay people. Alabama, Florida, Georgia, Idaho, Louisiana, Maryland, Massachusetts, Michigan, Minnesota, Mississippi, North Carolina, Oklahoma, and South Carolina. 3 states specifically target their statutes at same-sex relations only: Kansas, Kentucky, and Texas. Are you surprised?
So in Lawrence versus Texas, the United States Supreme Court basically said sodomy laws are a little bit bullshit, and they said that in 2003. Once again, that did not fucking stop anybody, including one Louisiana sheriff who spent 2006 and 2007 arresting gay men in parks. What were they doing, you ask? Great fucking question.
Yeah, agreeing to have sex with men in their homes.
While no charges have been filed against any of the men, they were still arrested, thrown in jail, and most importantly, outed to their community. The arrests created a record, and Louisiana is one of the 29 states without explicit employment protections for LGBT people, so that meant these men were at an increased risk of losing their job and not finding places to be rehired. This story comes out of the East Baton Rouge Parish Sheriff's Office, where a special community anti-crime team has been running sting operations in a community park. The team finds gay men, and an undercover officer invites them to come to their home for some drinks and some fun, and then they arrest them. It's literally fucking entrapment.
It's literally what happened all throughout the 1900s.
The same team also runs sting operations for child predators, but has been instead using its time and resources to harass gay men for doing constitutionally protected activity, like asking people if they want to fuck. The sting targets older men who are less likely to be openly queer. Louisiana is one of the 17 states that still have sodomy laws in their state codes. Although the laws are rarely ever enforced and even less likely to lead to convictions, it hasn't stopped police departments from using them to harass queer individuals. Officers in Michigan have run undercover operations to arrest gay men, and a sodomy law in North Carolina was used to charge 2 gay men with a felony in 2008. In June, Virginia Attorney General Ken Cucciolini asked a federal appeals court to uphold Virginia's sodomy law. His request was denied on constitutional grounds.
Thank fuck.
For real. So even when you have laws that prevent courts from securing a conviction against you that explicitly says you violated a law or you violated a statute, that doesn't stop police from arresting you and accusing you of a crime.